The final case for the docket on Monday, December 13th, 2021, is appeal number 122584, State of Kansas versus Paul Corby, Sedgwick County, briefed both sides. Your Honor, that concludes the docket for today.
Thank you, Mr. Shima. Counsel, I would like to have asked both of you to enter your appearances, and to do so, if you would please come one at a time to the lectern to state your appearance and then return to your counsel table, I would appreciate it.
May it please the Court, James Latta of the Appellate Defender's Office, representing Paul Corby. Ready for argument.
And may it please the Court, Assistant District Attorney Lance Gillette on behalf of the State of Kansas, present, ready for argument.
Mr. Latta, you may then proceed with your argument.
May it please the Court, once again, James Latta of the Appellate Defender's Office, representing Paul Corby. May I please reserve 3 minutes for rebuttal?
3 minutes is reserved. Thank you.
Thank you very much, Your Honor. As Your Honors know, this case has a very narrow issue before you. So by way of factual recitation for the audience and for your Honors, Mr. Corby had his probation revoked, was sent to prison, and then on appeal, we argued that his criminal history was not sufficiently proven by the pre-sentence investigation report in this case. And specifically, we're arguing about in-state prior convictions, the fleeting and eluding conviction, where the pre-sentence investigation report listed only the statute, and the statute has both misdemeanor and felony versions. So to get to what the conclusion in the end is, I want this court to find this case to be more like Obregon than the recent case of Roberts. And my argument for how we get there is that first, it is our position that Mr. Corby admitted to his criminal history as listed in the pre-sentence investigation report. That was the context of the sentencing hearing when they were admitting and not objecting, and that is also what the Court of Appeals found. Now, our next position is that the pre-sentence investigation report was incomplete when it came to the prior fleeting and eluding conviction. And so specifically, our argument is that the conviction code in the pre-sentence investigation report cannot be used to support the criminal history. And so I basically have more or less three reasons for that. Number one, in statute 216811, I think it is, where we talk about the defendant must admit in open court, or either the state must prove the criminal history. The phrase criminal history is defined, and the criminal history definition is criminal record. And so it's our position that the criminal record of whatever you have is, you cannot agree to the criminal classification, and that's what we have in the conviction code. So when Mr. Corby, in this case, agreed to his criminal history, which was the exact words used, he agreed only to the fleeing and eluding statute, but with no other evidence.
Well, it listed the fleeing and eluding as a felony, correct?
Yes.
And there's two different ways fleeing and eluding can be committed, either as a misdemeanor or as a felony. It listed it as a felony, and he essentially agreed to that, said that is correct. So isn't that a lot different, or at least it's significantly different than Obregon when there was no admission to anything?
I agree that is different.
And also, it just seems like this admission might be a little more reliable in the fact that we're dealing with in-state convictions. Obregon was an out-of-state convictions, in which you have that whole comparison analysis that has to be done. So doesn't this admission carry more weight than the lack of an admission and an out-of-state conviction that we were dealing with in Obregon? And pretty much follows Roberts, I think, but tell me why it doesn't, or what's wrong with that.
And this is how I see it different. So when we're looking here, we're looking for the substantial competent evidence to support the conviction. So we could use Mr. Corby's admission as that evidence to uphold it, except he didn't admit to the version. And the reason why I don't think you can use the conviction code as evidence is because when I think of it, I think of a case where, and I've seen this before, where we have PSI reports that list a different statute, and then they have a different description. So if the statute listed, let's say, was a misdemeanor, and the description was for a felony, and then we have the conviction code that says felony, I submit that we would not uphold that we would not use the conviction code itself to say that's evidence that he was really admitted to the felony version.
Isn't the rule that the defendant cannot stipulate to an error of law in the code, in the conviction code? But why would that preclude the defendant from stipulating to what's essentially a fact question here? Do you see a distinction there between, because it's certainly possible that your client was in fact convicted of a felony.
Right, yes.
It's just a matter of on the record, we don't know anything other than the defendant's stipulation to the PSI.
Right, and so I guess.
And couldn't that stipulation actually be true?
Yes, it could be true. And so our argument is that you cannot stipulate to your criminal classification, the conviction code. You can only stipulate to your criminal history, which just includes your criminal record. And our argument is that the criminal record is only of the statutes from which you were convicted.
But isn't the PSI report itself also evidence that the court can consider?
I think that part of the PSI is. I think part of the PSI where we have the statutes, the description, the state, that is evidence, and Mr. Corby admitted to those parts. I think we start moving over to something different when we get into conviction code. Courts can go in and change that. We all know from Wettrick, we can go in and change it if a prior crime was found to be unconstitutional. So I think when we get to conviction code, I've seen that more as criminal history score, and that you can't stipulate to that part of the PSI. Because it's more of more legal than factual is what my argument.
Isn't that the purpose of drawing an objection, though?
Yes,
The PSI report determining, well, that's not correct. I object. Isn't that the purpose?
I agree. So this is how I see moving through the statute. Mr. Corby admitted to his prior criminal history as listed in his PSI report. So he admitted only to committing a fleeing or eluding, but not the specific version. So then we look to the next part of the statute, which says, without an objection, the PSI report can often prove criminal history. So then we go.
Actually, it says it shall satisfy the state's burden of proof.
I'm sorry, shall satisfy the state's burden of proof. So then we go back to the PSI report to see if there's substantial competent evidence in it to meet that burden that Mr. Corby didn't admit to. And this is where I'm saying that not having the version of the statute, the state failed to meet its burden. And so I guess the main argument here to take away is that it is our position that the conviction code is not part of the stipulation, it's not part of the criminal history. Mr. Corby, in fact, only admitted to his criminal history, and that you cannot stipulate to the conviction code because we're getting more into criminal history scoring areas.
But for purposes of the scoring, does it matter? If it's a person felony, that puts you in a certain box.
Correct. I mean, I guess I don't fully understand. In this case, it matters because we're saying that he couldn't have stipulated to the felony, so therefore we need more evidence of the.
No, you said you didn't stipulate to the section number. So if there is more than one felony, for purposes of sentencing in the current case, does it matter? One felony or another felony?
In that case, it would not matter because we know that no matter what he admitted to, it would be a felony. But here we don't know for sure because we don't have the version listed, and this statute carries a misdemeanor and felony version.
But the PSI report said it was a felony conviction.
That's correct, and that's where my argument goes back to where we're arguing that the conviction code cannot be used to support the actual evidence because we're getting more into criminal history scoring.
Are there any cases that distinguish between the F and that the F for felony is not part of criminal history? Or is this a new argument?
I personally have not found any cases. I'm basing it off of the statute and the definitions for criminal history and criminal history scoring, and arguing.
I'm sorry, and that's where I was going to go with my question, because if you look at the statutory definition, it does distinguish between criminal record, or criminal history and criminal history score. And criminal history is the record But in the statutory definition, it says, includes an offender's criminal record of felony, misdemeanor, and juvenile adjudications. So, and then in the criminal history score, it says that is a summation of the convictions described in the criminal history that place the offender in a score category. To me, that definition the first definition of criminal history seems to indicate that you are, in criminal history, looking at whether it's a felony, a misdemeanor, or a juvenile adjudication.
Sure, I would offer a little different reading of it. I look at it more of an inclusion of what we're including. So I know it says, adult felonies, misdemeanors, but to me, that's just what all we're going to include. So when you admit to your criminal history, you're just admitting to the statute and not the crime classification, would be my response to that.
And does it matter how the PSI itself is laid out on the paper and the labels that are put on it? Because isn't the grid part that says criminal history just numbers? And that fall into those categories? I mean, for example, it's hard, I wish this is where we could screen share, I guess, on our Zoom. Because if you pull up the PSI, there's a category in your table with the heading current crimes of convictions. And under all of that in the table, there is a description, and then there is a column for misdemeanor felony, a third column for person, non-person, and a fourth column for the level. And then that whole part of the table stops, and there's a new overarching description that's criminal history. So all that to say that the misdemeanor and the felony on the table falls under current crime of conviction description, which again kind of goes back to that part of the statute as opposed to the criminal history score. So do we give any weight to how the PSI was, because the PSI is statutory in the form?
Sure, and if I understand you correctly,
I mean, is that giving us a hint of legislative intent, I guess?
I believe so. So when I look at these PSI reports, I see there's two different areas. There's an area where crime was committed. They list that, they list the description, the state, everything. That's unchanging. And then I see it as shifting into more of we start getting into legal questions, not just hard fact questions of was this crime actually committed? And that's where I'm trying to sway this court to see that the conviction code is getting more into criminal history, where there's other questions to be asked other than was the underlying crime really a felony? I mean, maybe the underlying crime was a felony when it was committed and it changed later. And I would submit that given if it changed before the current crime, yes.
Let me understand, what's the trial judge, the sentencing judge supposed to do? When he asks defense counsel, there's no objection to the criminal history score? No, there's not. And then his client, your client, says, do you personally admit the criminal history is correct? Yes, Your Honor. There needs to be further inquiry other than that when it's just clear they both agree this is my criminal history.
Sure, I see the issue, and I see the error.
And so and then Roberts, we say once that happens, and here it's even clearer than Roberts, I believe, then the burden, and I'm certainly aware of the dangers of shifting burdens in criminal cases, but isn't the statute clear that after that occurs, then it's up to you to come up with later, especially when it's brought up later on appeal or in a subsequent proceeding? Yeah, go ahead. Why doesn't your client then, hey, wait, this is right? Because you're just guessing at this point.
Right, I understand that. I got two responses. One, I see it more of an error of the state. If the state would have stood up during sentencing, it doesn't even have to amend the PSI. They could have stood up and said, well, we're missing the version here. Mr. Corby, will you admit that the version was subsection B? And in open court, if Mr. Corby admits to it, then that's his admission. So the admissions, I still think we have to look to substantial competent evidence of what we're admitting to see if we can uphold these criminal history scores on appeal. So he admitted to just the whole statute. So I don't see that admission as being substantial competent evidence of the prior conviction. And that's why on appeal, that's why I was making my argument earlier of how we go through the statute. And then now we say the PSI shall be evidence, and then there was no objection. So therefore, we look, what we have, and that would be, we would ask for a remand then for more proof under Obregon. If there's no other questions from your honors, we would just ask for a remand and new sentencing hearing on this issue.
Questions? Thank you, Mr. Lana. Mr. Gillette?
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state. I would start by reiterating what the Court of Appeals panel in this case explained, and that the time and the place to challenge the fact of a conviction listed on a defendant's criminal history in the PSI is when the defendant receives the worksheet before he or she is sentenced. Today, I'm simply asking this court to follow and apply the plain language of KSA 216814. And that statute is clear that when a defendant admits his or her criminal history, and it is then established, if a defendant seeks to pursue a later challenge, which is what this case is, the burden does shift to the defendant. And that is not a burden that should be concerning to anyone, because it is the defendant who arguably has some of the best knowledge about exactly what his criminal history is. I want to first,
Counsel, just real quickly, does that mean that from the state's perspective, if the defendant did come forward with evidence that, hey, this really was a misdemeanor conviction, the state would basically say, okay, then it was an illegal sentence?
Correct. And it's something that we can and have done many times and are perfectly capable of doing. And I think that is one key here, is that a defendant just needs to come forward with something. That is not a big ask, I guess, in this case. There are two additional points I think I want to talk about a little bit today, and that is the admission and what this APF, the adult person felony, what that really means. To that end, I would first point out that argument is a little bit of a shift from what we saw in the opening brief here, in which the defendant just claimed that the state failed to meet its burden. So I'm not even sure that argument is properly before this court. But even assuming that it was, Justice Lukert, I think you hit this right on the head, that when a defendant admits to his or her criminal history, that includes that column as you're listing off the columns. It's not just a listing of the statutes in column A. It is an admission to the record of his or her criminal convictions and their classifications, adult person felon, or their felonies, misdemeanors, et cetera. And I think that the statutes are clear on that, 2168, 10, and 11. And it's clear why they are so clear on that point, and it's because the KSGA's entire goal is to ensure uniformity in sentencing and that individual offenders are punished appropriately for their crimes based on their history. The second thing I wanted to talk about here a little bit is, Justice Rosen, your question is whether or not a defendant's admission carries weight. It absolutely does. KSA 2168-14A is clear that an admission is all that is necessary to establish criminal history. That's it. The other cases, Obregon and the like, what we have in those scenarios is distinguishable, because in those cases we do not have an admission.
Isn't the admission just part of the calculus the trial court must undertake in determining that there's a preponderance of the evidence satisfies what the criminal history score is? We have an admission. I mean, in my mind, we have an admission plus in-state convictions that are listed as a felony, and given that kind of weight, that would satisfy the state's burden in showing that that's what the criminal history is accurate.
Two things there. I think that
Because Obregon just says that admission's enough.
right.
And I think it's a little more than that, but here we probably I think it's satisfied, but what do you think?
I would accept both routes in this case. I think that under Obregon and as appropriate under the statutory language that an admission is enough. And I think that here, the admission would carry even greater weight than if we were dealing with something that was an obscure out-of-state statute like some of them that we have seen coming out of Florida and other states in the Wettrich line of cases. So I think that the admission here would carry more weight if it wasn't alone sufficient.
Well, it strikes me that some of the confusion in this area of the law stems from the fact that sometimes the scoring actually turns on a question of law, and sometimes it doesn't. And so whether or not I just want to put a proposition to you and see if you agree or disagree. The proposition might go something like this. When a defendant stipulates, the evidentiary value of that stipulation really turns on whether or not the scoring represents a legal determination or a fact question. Because I think we've said, and generally it's true, that a party cannot stipulate to an error of law.
That is correct in the same sense that a defendant can't agree to an illegal sentence. But I think it begs a question, and I don't think I would necessarily draw that fine of a distinction on it, because the statute is clear and it doesn't make any kind of an exception for treating an admission differently, whether it is admission to a fact or to a prior's classification. That classification is also arguably a fact, but it's driven by the law.
Well, let's just say, for sake of argument, in this case,
Sure.
that the classification of this crime as a felony on the PSI was just flatly erroneous as a matter of law.
Okay.
You wouldn't be here arguing that the stipulation still binds the defendant to that error of law, would you?
There are two steps. A, I would say it binds the defendant, but B, he has then come forward with information that would carry his burden of proof at this point by preponderance of the evidence under subsection C of 2168-14.
That information being that it was an error of law?
Correct. And I think that that's how we can resolve both of those types of situations. So I guess the final thing I just would conclude with here is that my friend on the other side mentions that the state could have simply stood up or done something more. There was nothing to prompt the state to do that here. That prompt is triggered by the defendant's objection, an objection that is also required by the statute. I'm simply asking the court to follow the statute in this case. His admission means something. He's done nothing to try to carry his burden to overcome that admission at this point, and he should be denied relief akin to Roberts. If there are no further questions, I thank this court for its time.
Latta, you reserve 3 minutes.
So I don't have much to say. I would just say I think I raised some of the conviction code argument on page 11 in my petition for review, and that's when it became issue. And the only other thing I would say is I just feel like I need to do this for my clients is Mr. Corby had a lengthy criminal history. It's really asking a lot that he know every conviction, and I think it'd be easy for all of us to remember if we had a prior conviction. But some of these clients of mine, it's really tough, and it's really difficult to ask for them to know their classification as well, in addition to their underlying conviction.
I have a hard time buying that argument because I understood you to say that if this PSI had said, this guy violated XX 201A, holding to that, and here, in my example, 201A is the felony and B is the misdemeanor, and the PSI says he was guilty of 201, the felony, that somehow that's beyond his comprehension. And now you're telling me that it's okay if the PSI says sub A or sub B, and that we then hold him to that admission. That doesn't follow.
I understand. My answer to that would be that that's what the statute says, is criminal history. And what we go off of criminal history is a prior criminal record, and the prior criminal record is the statutes listed. That'd be my response to that. No other questions, that's all I have, Your Honors. Thank you.
Thank you to both counsel for your arguments today. The court will take this appeal under advisement.